Welcome back, 9:53, and the Supreme Court is issuing a flurry of final opinions before they go on summer recess.
That's right, and one upholds state laws banning transgender athletes from girls' sports. We have North Central College professor Stephen Caliendo with us once again. We're also going to bring into the conversation Northwestern law professor Kara Engelhardt. Kara, thank you for your time this morning. What was your takeaway from this ruling?
Yeah, like many, I have been waiting on this decision with trepidation and have quickly reviewed it. I thank you so much for focusing on this story this morning. It's really important to talk about this disappointing and confusing decision about the legal recognition of trans girls' experience as children. I think it's so important that we talk about this to have an accurate understanding for your audience of the first impression in its meaning. I'd really like to take more time to carefully review it, like so many, but what happened today is that the Supreme Court decided two cases in one decision. They are the cases West Virginia v. BPJ and Little v. Hecox. And like my colleague said before the break, all the justices concurred that states may treat trans girls differently than cis girls under Title IX. There was disagreement about whether that's true under the Equal Protection Clause of the Constitution. And again, why I think this is so important is that this decision creates a ton of confusion in the law after the 2020 decision authored by Justice Gorsuch in the case of employment, where the federal law with the term sex means one thing there, and now it suddenly means something different in a different context.
So what do you worry will happen with regard to those two things being opposed to one another? What do you worry the real world fallout will be?
Well, first of all, these two cases are about two girls. It's important for the general public to understand that there has been so much attention and resource devoted to two girls in this whole country, and they are wonderful, and they just want to achieve and take part in sports like anybody else. But what I think the law is at its foundation is a human-made set of rules, right? And so the law can certainly say whatever the Supreme Court decides it should say, but the law also is supposed to do is give people predictive value as to the understanding of their own rights and the obligations they owe other people. And so it's when you have something like this, where under Title VII in the employment context, we say it's discrimination when you treat people differently based on sex, and sex means women, trans people, LGBT people. But when you treat trans people differently under Title IX, the term sex doesn't include them, and treating them differently there isn't discrimination. That creates confusion for people in the real world. How do you go about setting up programs where you have to have difference across different contexts? But also it creates an opportunity for sort of bad actors to take advantage of that, to say the law is confusing, and so I don't have to treat people equally or give everybody the same access because this is a different context than that. It allows all kinds of parsing when we know that trans girls are a small portion of the population who just want to participate in sports or just want to participate in school activities and shouldn't be barred from doing so.
So the professor was discussing how this is a difference between the employment categorization, I can't even
categorization,
right.
Title VII.
You know what I mean? Versus a sports definition. But I think some parents might argue, but employment and the physicality of participating in a sport are two different things, right? Yeah. So there need to be two different definitions.
And I think the justices were getting at that a little bit in some of the opinions. And they talked about the sort of the complications of the science. It's an emerging issue. It's a sensitive issue. And really what I thought was interesting is that they essentially advocated for some judicial restraint. In other words, it wasn't a strong statement about whether something is right or whether it's right or wrong. They're saying sort of here's where we are with Title IX, here's where we are with the Equal Protection Clause. But we need to, there's more to be done, and the court should not be weighing in on this. We should allow this to be left to the state. So there's a number of ways to read these opinions. You could read it as a real victory for anti-trans rights folks, but you could also read it as an indication that the court is saying this is so new and there's so much science still to be done, and there's so many complications. This was the case in the Roe decision in the 1970s, right? There was a lot of scientific elements. We don't think about that part of it, but I think the court acknowledged that and said, best left to the states at this point.
Kara, let's go back to you. Can you explain to us non-law people, this case was out of West Virginia and Idaho, the implications on the rest of the country from here?
Yeah, that's a really good question. This decision applies to those two states. Other states have similar laws and policies. So those states that have exclusive policies now can go forth and do that. But there's no obligation on states like Illinois, where there are statutory protections for trans kids in school. They can still participate in inclusive ways, and the states that have those protections can still maintain those and enforce those.
So this is not a domino effect that will just go all 50 states. Okay.
I think that's correct.
Is it a case right now, Professor Caliendo, where if you are a trans athlete and you want to play collegiate sports or even high school sports, a family might move to one of those states that are more friendly to those types of athletes and allows them to participate?
Yeah, I think with respect to collegiate sports, you often don't I mean, you might have in-state tuition versus out-of-state tuition, but you can't just move there for college. You have to sort of establish that. I think with respect to college, though, athletes will be making decisions about where they can play based on what states are going to permit it, particularly if they're state schools. We don't know where we are with public schools on some of this yet. So the states can prohibit this. We haven't had a case dealing specifically with I said public, I meant private schools. We know where we are in the public schools, and so there definitely will be decisions made on that grounds. Again, I don't think families typically move to establish residency for college that often. They may choose to move on the K through 12 decision.
Right. Sorry.
Absolutely. No, you're right. No, that's okay. It's fair because especially with in-state tuition on state colleges. But I think that we definitely were going to keep our eye on the next group of these cases coming through, which will really push the limit about whether trans athletes can be protected by the Equal Protection Clause or whether they're prohibited from being protected by the Equal Protection Clause because cisgender athletes have rights as well.
Professor Caliendo, Kara Engelhardt, thank you both so much for your time. Really appreciate you joining the program this morning. Thank you.
Thank you for covering this important issue.
Yeah, absolutely. Okay, so we're